Here's the serious legal question, folks. If a criminal commits a violent crime with a firearm, should the manufacturer of that firearm be financially responsible? Not the criminal, not the person who illegally transferred it, not the person who pulled the trigger, the company that built it. Because that's exactly what several states are trying to make happen, including New York and yes, New Jersey. And now this very issue may be headed to the United States Supreme Court. Today in this video, I'm going to break down this clearly, what the Protection of Lawful Commerce in Arms Act actually does, what New York passed, what New Jersey passed, how background checks and federal law already work, and why this case matters to every lawful gun owner in this state and others. Let's get into it. Back in 2005, Congress passed a federal law called the Protection of Lawful Commerce in Arms Act, also referred to as the PLCAA. The purpose of the law was straightforward. It prevents gun manufacturers and dealers from being held liable for crimes committed by third parties using their products. This wasn't some random law. It codified a long-standing principle in tort law, which essentially means you're responsible for your own criminal conduct. If someone commits armed robbery, the criminal is responsible, not the manufacturer of the firearm. Someone drives drunk and kills someone, Ford is not responsible. Someone commits assault with a knife, the knife company isn't responsible. The NRA recently published an article explaining that PLCAA was passed to prevent exactly the type of lawsuits we're now seeing revived in states like New York and New Jersey. I'll put a link in the description to the article if you're interested in reading it. By the way, the federal law does not provide blanket immunity. If a manufacturer knowingly violates a law, for example, illegal sales or regulatory violations, they can still be sued. But they cannot be sued simply because someone criminally misused a lawful product. That distinction is what matters. So back in 2021, New York passed Senate Bill 7196. It created liability if members of the firearm industry fail to implement what the law calls, quote, reasonable controls, end quote. The problem here is that reasonable controls is vague. The NRA article explains that the petition argues New York is attempting to reinstate liability that Congress expressly prohibited under the PLCAA. So this is exactly what that federal law is supposed to prevent. In other words, the argument is that Congress said you cannot sue manufacturers for third-party misuse. So New York responded, and New Jersey did as well, by redefining the claim as a, quote, public nuisance. And of course, using different language to get around the federal protections. The National Shooting Sports Foundation and the manufacturers have petitioned the Supreme Court to review this under a Supremacy Clause argument, essentially saying that federal law overrides conflicting state law. If the U.S. Supreme Court takes this case, it could decide whether states can do this. Can they really sidestep federal protections through creative drafting of laws? Now, if you're from New Jersey, you should know that they did this same thing. New Jersey passed a similar law. In 2022, New Jersey enacted A 1765 and S 1204, which was of course codified into law under NJSA 2C 5833 all the way through 2C 5838. This law allows civil lawsuits against firearm industry members for creating or contributing to a, quote, public nuisance. There's that language again, same language that New York used. That's what these states do. They copy and paste. They copy what one state does with the language and the words and the definitions, and they use it to draft their laws. It includes language requiring, quote, reasonable controls, there's those words again, over sale and distribution. Very similar in structure to the New York law. New Jersey also authorizes the Attorney General to bring civil actions. But the key point for New Jersey gun owners, folks, is this. If the Supreme Court sides with the New York law, it strengthens New Jersey's framework and for their law, of course. If the court strikes it down, however, it directly impacts New Jersey's statute. The same thing happened after the Bruin decision came out in New York. New Jersey Attorney General's office had to respond and remove the justifiable need requirement for New Jersey carry permits. So they had to respond after the Bruin decision. So let's talk about what's currently required by manufacturers and what's in the law now when you want to go buy a gun. Manufacturers cannot sell directly to the public. They sell to federally licensed firearms dealers or FFLs. So at the point of sale, when you go to buy the gun, you as the buyer have to complete that ATF form 4473. You have to answer all those questions. The dealer then has to run a background check through NICS, the National Instant Criminal Background System, which is the federal system for doing a background check. However, in many states like New York and New Jersey, there's an extensive background check done before you ever even leave your house or go to the gun store. In New Jersey specifically, if you want to buy a handgun, you have to apply for a handgun purchase permit, which requires a complete background check, a waiting period. Long guns require that firearms ID card. So after that waiting period and the police department makes sure you're not subject to any of the disqualifiers that are listed in the law, after your name and information is run through mental health databases for checks on mental health history, in states like New York and New Jersey, all this happens before you even go to buy a gun. When you actually do find a gun to buy, you still have to complete that NICS check at the dealer at the point of sale to make sure that, for example, you weren't arrested yesterday or 4 hours ago, or you weren't flagged for some other reason like mental health. So when a state says manufacturers must ensure that guns don't get into the hands of, quote, irresponsible people, what exactly does that mean? They already manufacture a lawful product, sell to licensed dealers, comply with federal regulation, comply with state regulation, operate under ATF oversight. They do not conduct background checks. The dealers do. The government does. The NICS system exists for that purpose, that last-minute final check to ensure that a recent arrest or flag wasn't missed. So the legal question now becomes, how far does liability extend for a product that passes through multiple regulated checkpoints before reaching a consumer? That's the real issue here. Car manufacturers are not liable for drunk drivers. Alcohol companies are not liable for DUI crashes. Pharmaceutical companies are not liable for criminal misuse of medication when properly manufactured and sold lawfully. Internet service providers and social media platforms receive liability protections under the federal statute, Section 230, for third-party content posted on their services. Why? Because we recognize that third-party misuse breaks that chain of liability. How can an internet service provider company be responsible for a person on their computer or on their phone posting something on the internet or doing something illegally? The PLCAA applied that same principle to the firearms industry. So the question really here, folks, now is whether states can override that by redefining the liability. Folks, this is not about defending criminals. Criminals are responsible for crime. I investigated violent crimes in my years in law enforcement. The person who commits the act is responsible. But here's what happens if manufacturers can be held financially responsible for criminal misuse. Your insurance premiums are going to go up. Small manufacturers are going to disappear. Of course, product lines are going to shrink. Costs are going to increase. Litigation now in the courts is going to become regulation. That's really the broader concern here. So if liability can be expanded in one industry based on third-party criminal acts, the precedent doesn't stay contained, right? It can move on to other areas. This Supreme Court petition could determine whether federal law still provides national consistency or whether individual states like New York and New Jersey can redefine liability through their creative writing. So for New Jersey gun owners, this case really does matter, just like the Bruin decision. Our statute obviously mirrors the framework being challenged in the New York law. Whatever the Supreme Court decides will have that ripple effect here in New Jersey, just like with the Bruin decision. I should mention, folks, that I'm not a lawyer, and this, of course, is not legal advice, but I do think it's a major legal development. And if you're a gun owner in New Jersey or New York, you should understand what's going on here. Let me know your thoughts in the comments, and if you want continued updates on New Jersey firearms laws and how these cases affect you directly, make sure you're subscribed. We'll keep you posted on this case. As always, thanks for watching, take care, and stay safe.